Hello, hello, hello. It's Attorney Mike Raven coming to you from Chicago as usual, and I collected what I could. It was a slow court day, but I got some interesting stuff. And one of the things, Rosalind Duke came through for some reason today. For some reason, I say that because she kind of owes me. She kind of owes me because she's responsible for this. You see what I'm saying here? Anyway, she put me onto this this order, the terms of disposition or sentence in the Craada affair. And this is from today. This is fresh off the presses, and I think it's very reasonable from what I can see. But the sentence, it says defendant is sentenced to 30 days in Kindayohi. Is it Kindayohi County Jail? Defendant is to serve 30 days. Credit for time served amount is 2 days. I think those were their initial 2 days when he got pulled in. May be deferred if compliant with probation. Start date August 1st, 2025. And then monitoring, defendant is placed on supervised probation for 5 years, monitored by the Candy-Yohi, the Candy Ass County. I'm sure that's what they call it. I'm sure that's what the high school kids in the county call it. I'm sure. Probation. So he's got 30 days that looks like he doesn't have to serve, and 5 years probation. It's about what I predicted. I think he'll be fine. I wish him well. If he stays away from the alcohol and drugs, I think he'll do just fine. He doesn't have a big criminal history. He went off the rails. Man had himself a little midlife crisis. These kinds of things can happen. I hope he gets it back on track. I don't know. There's more stuff in there, but I'm sure he has other issues with I don't know, actually I'm not sure, but I'm guessing he's got some issues with the Department of Children and Family Services, or whatever the hell they call it in Minnesota, to make sure that they're probably monitoring to make sure the kids are safe, and some other stuff. But basically, he's gonna probably, if he can behave himself, he's gonna get through this with a couple nights in jail and loss of a ton of money and a ton of reputation. But other than that, if he can behave, it looks like he's back to semi-normal status. Other than random like in there, he's not supposed to drink. He's subject to random alcohol testing and all that kind of stuff. And I think that's good. I think that's it. And by the way, people will speculate that he got some special treatment. I don't think, because he's an attorney. No, if anything, that makes it worse. This is the sort of thing that you would typically see anybody get for when they have no criminal record, and the first time they lose their way, you get a lot of breaks. If you keep doing it, it turns ugly. All right, let me see if I can find my regularly scheduled clip. Let's go.
Green versus Dustin Nicholls.
This is also Rosalind Duke's fault here.
Yes, there's Carla Green, Dustin Nicholls, and Antoinette. State your names.
Carla Green, Antoinette.
Dustin. All right. Where are we on this, folks? Because
I filed the proper paperwork.
Well, I don't know that you
did. She say her name is Collard Green? I swear I had that name on here before because I was laughing about it.
did. Okay, so here's the problem. I don't think that I have subject matter jurisdiction over the case, and let me just explain it so everybody knows what I'm talking about. In order for the court to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit. when we were here, and I kind of explained it the last time that we were here. When we were here the last time, you were indicating to me that you gave them a notice to quit on the case. I didn't have it in my file. And I kept asking you, well, when did you serve it on them? Because I think they were saying they hadn't gotten a notice to quit. So I said that I had to have the one that has the proof of service on it. And I adjourned it out to give you an opportunity to correct that. Because if it had been served, it was. So you filed with the court a notice to quit.
Yeah, you got to have service to get jurisdiction. This isn't soft sit stuff. This is everyday reality in court.
And importantly, on the notice to quit that you filed, it says that they had to move by February 28th, 2025. And that you served it on them March, as I'm looking at it here, March 10th, 2025. Is what it looks like to me. And it says it's served by first class mail. Assuming this document to be true, I don't have jurisdiction over the case. And in fact, I'll just say this, this document, if that's the March 10th date, it can't be, because you can't tell someone they have to move by the 28th of February and not give them notice that they have to move until March 10th. The only way that this notice, as it is signed by you, can make sense is if it were served on them on March 10th, they would have until April 11th or April 10th in which to move. So when I look at the face of the documents, this notice is invalid. With the dates that are on here, it can't be true.
Additionally, went with that notice to quit, had this file, had the police officer do it the correct way, because that's what I was told to do from this court. The notice to quit. You said that I had to show proper paperwork of.
Yeah, you do. And don't blame the judge. This is my second time through. I didn't catch this first time. Blaming the judge for effectively giving you bad legal advice is not a good tactic. It's wrong and it's not true, but it's bad on so many levels.
Me serving them the correct way. So the first time I served them was January.
And we went through this the last time. You gave me, and when you were talking about the police officer serving, that's the service of the summons and complaint. That I don't necessarily, as I'm looking at it, have a problem with, that they would have received a summons and complaint from the court. They would have had an officer or somebody show up to serve that. That I'm not having the issue with, and that's what I was just trying to explain at the last hearing. Because the document you handed me, that you were talking about that. What I told you was the notice to quit. I didn't have a copy of when it was served on that. Gave you the opportunity, you said you did, I gave you the opportunity to correct it. I'm not sure what date it was received, but the document that we received that was received by the court is a notice to quit to recover possession of the property. I will say two things about that. First of all, it doesn't match. The top portion of that notice to quit does not match what I have in the file, which leads me to believe that it's not the document that was served on them if it was served. Then even aside from all of that, and so in reality, it's not a valid notice to quit. But even aside from all of that, if I were to say, give me the benefit of the doubt, I'll just look at it, I'll take the dates. You can't give somebody a 30-day notice, tell them to move by February 28th, and not tell them until March 10th.
Your Honor, I think it's a misunderstanding. I served them a notice to quit on February 28th because I'm following all the court steps. She said, first of all, you have to file a notice to quit yourself. And then if they don't move, you come to court, you file this paperwork, and then you come to court. So I served them, correct?
No, you don't get the question. What are you saying? You have to give me a proper service here. And I don't have it. I don't know what that notice to quit. You keep saying that you gave them one. I don't know what it says. Because your two notices to quit are different. The one that you gave me just recently is different than what was attached. The top portion is different than what was attached to the complaint that was filed. One
Yeah, that's a problem. I mean, that's a big problem.
is typed, the other is handwritten. It says move by the 28th, but the way it works on a 30-day, I tell you, if I were to give somebody right now a 30-day notice today, the 18th, I would say, if I serve it on somebody today,
Your Honor, I served it on January.
just don't interrupt me. April 18th, I would give them until May 18th to move.
Correct.
I'm getting that sensation, Pegleg.
Your notice, on the other hand, says you have to move by February 28th, but I don't tell you that until March 10th.
That's the second.
Can't work that.
That's the second notice, Your Honor. The first notice, they told me to serve it. You have to have a 30-day.
Thank you, Rosalind.
I served them the 30-day notice to quit, January the 28th. So they had till February the 28th to move.
Then why don't I have a proof of service that it was given to them on January 28th? I don't have that. I told you to come back, and usually I wouldn't do it. Usually I would have kicked this case the last time. You kept telling me that you had it. I see a notice. I don't have the proof of service on the notice to quit. I gave you an opportunity to correct. What I got
Your Honor,
is an impossibility.
Your Honor, what you got is what the court told me to do. They said file a 30-day.
You're not going to blame the court. The court didn't tell you to do this, because I think this is a falsified document if you want to really get down to it. Because the notice to quit that I have in the file is typed. The notice to quit that you gave me is handwritten. It can't be the same. I don't want to accuse you of providing false documents to the court, but that's certainly what it looks like. And secondly, the date, as I indicated, and I will say, you can smile at me all you want, but I'm going to tell you right now, if I think you filed a false document, you're going to get a show cause, and you're not going to like what happens. Am I clear? The document that you gave me is a factual impossibility. You cannot tell somebody to move February 28th and serve them on March 10th. It can't happen that way, because you're telling them to move after the time that you told them to move. You can't do it. That's what's in this file. So giving you an opportunity to do that, I've given you an opportunity to correct it. You failed to correct it. I will state on the record, I think you provided to the court a false document. This court lacks subject matter jurisdiction pursuant to the cases decided by Michigan Supreme Court. I don't have jurisdiction over this case. The only thing that I can do is dismiss it. This case is dismissed for lack of subject matter jurisdiction. Thank you. What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
All right.
Your Honor, are we?
I'll move it back just so you can't really tell what she says.
There. Correct it. You failed to correct it. I will state on the record, I think you provided to the court a false document. This court lacks subject matter jurisdiction pursuant to the cases decided by Michigan Supreme Court. I don't have jurisdiction over this case. The only thing that I can do is dismiss it. This case is dismissed for lack of subject matter jurisdiction. Thank you. What'd you say? Ma'am, you better Bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace because when she comes back in here, it is gonna be a mess.
It's gonna be ugly.
Don't go out into the hall yet. Call security down. I don't just want to say who wants to go next. But they're coming down. I'll wait for her to come back here. Everybody doesn't have to wait. Parsons. That matters dismissed on plaintiff's motion without prejudice.
Sorry to interrupt. Your Honor, are we allowed to leave you?
I'm not clear what's going on out there.
Okay.
All right, so if you just sit tight, he was trying to explain something to me. I was trying to finish up that case and do we know?
We do now, sorry. Would you like me to?
Well, no, because I don't know what's going on out there. All right, you two, since you're the one that caused my troubles. No, I'm kidding. You two sit right there until we tell you to leave. All right? So that'd be simple. The rest of the people here are probably for my next block, which I'm just gonna let you know right now is gonna be a bit delayed, but I will get it called. And I'm gonna step off the bench and try to figure out exactly what's going on. Okay? Thank you, folks. Court's gonna stand in recess.
14A District Court for County, Washington, State of Michigan is now back in session. The honor
You may be seated. Okay, you two. She's out of the building and clear. You can go. All right?
Thank you.
Just give us a heads up when you're gonna grace my doorstep again, all right? You guys take care. Have a great weekend. Almost don't want to call anymore. I guess I will. Is this that?
This is one I just had to catch up on. It's short. Kim Blendino's back at it. It's kind of fun.
Case A 907-619, he's present.
Good morning,
Shout out to our Nevada judges as usual. I don't know what the sticker on his suit says.
Judge
that
Kim
number
Blandino,
40.
appearing for Kim Blandino.
And Mr. Dickerson is here. I just wanted to hear if the state had any response.
I'd like to note though for the record that they filed no response whatsoever in writing. Therefore, anything Mr. Dickerson has to say can't really be serious. If it was serious, he would have put it in the paper.
Everything that I say.
Thank
is
you very
serious.
much. Go ahead.
Thank you. Our position would be
That was actually good from Dickerson. he just said everything I say is serious. And then he carries on.
this, is that the defendant has shown no basis for two things. Number one, to regain his right to self-representation, which seems like he's trying to end run here without explicitly saying so. Seems like that's what he's trying to get at. Number two, for taking Mr. Gerstein off the case. Mr. Gerstein has done a fantastic job for the defendant. He's fought tooth and nail at every corner, and there seems to be no basis for his motion and to expend unnecessary resources by appointing somebody new, and especially with such a difficult defendant, to appoint somebody new to have to take on this defendant, and who knows where that goes. There's also really no reason that any new litigation needs to be occurring. I do think that there's possibly some litigation going on with Metro right now, but I don't know that that's even in this case. I think that's in the Justice Lord case. So at this point in time, for three reasons, the self-representation has been revoked. There's no reason to renew that and give him another chance at it. Number two, there's no reason to take Mr. Gerstein off the case. And number three, there's no basis for there to be anything going on in the case since the case is closed.
Well, it's a new proceeding. He filed a post-conviction.
Yeah, what's
So it's a new proceeding.
Stop interrupt.
So, anything else?
Yeah, I'd like to reply to that. This man here is slightly delusional because this is the writ of habeas corpus. It is also known as the Great Writ, comes down from the Magna Carta to challenge the legality of the custody.
Here, we're just on the appointment of counsel issue.
Exactly. I filed this representing myself, which I have the right to do, under witness and under the case law on this, which I outlined clearly in there. I don't know if Mr. Dickerson even read this motion.
No, I didn't, because I was not served with that, Your Honor.
He was served with it. If he's going to deny service, I'd like him to do that under penalty of perjury.
My goodness.
So the case is clear on habeas representation and we went through this the last time. A, is the issues presented are difficult, and B, counsel is necessary to proceed with discovery. This being a new case, the revocation of my right to represent myself in the main trial has no bearing whatsoever on this. That's not a perpetual thing that goes there every time I come into every courtroom. Although Mr. Dickerson in Justice Court made it clear to present what happened in this court, and Judge Sacento denied me the right to represent myself in the Justice Court, which should be
Okay.
a disciplinary thing with the bar. But the issues are difficult under
Why?
Brown versus State Judicial District Court. Counsel is necessary to proceed with discovery. I'm going to have a lot of discovery because the witness is called. You, Judge, do you know that Paul Dyla came and testified against me? He was not called as a witness on direct. He could easily have done so, and they're going to have to subpoena Ducis Tecum, all the evidence that they have at the Commission on Judicial Discipline for this. That's a massive undertaking, plus the letters of caution that were issued based on my complaint. He's going to have to
Okay.
testify.
All right. So
Okay.
at this time, I think I've heard enough. The court will issue a minute order. Thank you very much.
So
You're not going to say what your
I'm going to
determination.
issue a minute order.
Okay.
Thank you very much.
Okay.
could I just make a quick record that anything that he's serving regarding a petition for writ of habeas corpus needs to be served on the DA's office. It's going to be handled by our appellate section.
I don't know where he served it.
Yeah, I don't know either. I haven't seen it.
Where'd you serve it? Did you serve it on? I'm assuming you did because you're telling me you did.
Now, the petition is not required to be served. I was presuming he's talking about the motion, but
For the motion.
Talking about the
I
petition.
did serve him by email on the this motion for
Come on, Kim. It says it right there in the Magna Carta.
leave for standby counsel.
All right. Thank
And
you
if I
very
didn't,
much.
I will let the court know if there's a clerical error on my part, then I'll admit to it and fess up. But to my knowledge here, I did serve him. But the other thing,
I
Judge,
appreciate
as
it.
you know, I'd like to have the transcripts as usual.
No
And
problem.
can you order that I get the jabs as well at no cost? Yeah, thank you.
That's right.
Thank you,
very
Judge.
much. Have a good
day.
one.
Your Honor.
State of Ohio versus Andrea Wasik, case number 24 CR 1364. Defendant is present.
Oh, this is another Minecraft courtroom. It takes a minute to get going, but we've got a Karen in here who wants to plead guilty but not take responsibility. You know that routine. The judge gets is kind of fun about it.
And represented by defense counsel Nicolette Tomasic. We are here today for a change of plea. It's my understanding that the defendant wishes to plead guilty to count 1, assault on a peace officer. It is also my understanding that there is a joint recommendation for community control after a pre-sentence report is completed.
Thank you. Ms. Tomasic, does that sound correct?
That is correct, Your Honor.
Ms. Wasik, did I say that right? Wasik?
Yes, Your Honor.
You can be seated during this. It's going to take some time. I don't interpret that as any disrespect or anything, so it's easier to be sitting down when we do this. But were you able to hear what the prosecutor had to say regarding what she believes your intentions are here at this time?
Yes, Your Honor.
She indicated to the court she believes it's your desire to withdraw your previously entered plea of not guilty and enter plea of guilty to count 1 of the charge of assault on a police officer felony in the 4th degree. The other 2 counts would get dismissed pursuant to the agreement. We would defer, continue the sentencing to a later day to get some reports completed, come back on a future day for sentencing where there will be a joint recommendation presented to the court that community control sanctions be imposed. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk to your lawyer so you can ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, ma'am?
58 years old.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No, Your
What
Honor.
about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No prescribed medication, anything.
Now, you should have received, I think you did back in beginning of March, a copy of the indictment in this case, and in February, beginning of March, which is the document that sets forth the 3 specific charges you're accused of committing. Do you remember getting that at some point?
Yes, Your Honor.
And at some point, did you have the chance to look that over?
Yes, I did.
Now, in that information, as it said, you're charged with 3 counts. You're pleading guilty to count 1. What's alleged here in count 1 is on or about November 12, 2024 in Painesville Lake County, Ohio, that you did knowingly cause or attempt to cause physical harm to Officer Brandon Smith, the victim being a peace officer while in the performance of his official duties, which makes the offense assault, a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, there are 2 other counts of this indictment that will be getting dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about either of those?
No, Your Honor.
Well, then, before I can accept your guilty plea to count 1 that I just read to, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, do have the right to have a trial in this case. And that trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Give me 1 second here. All right, well, do you have any questions at all then regarding the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer and have her go over everything with you and answer all your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has she or has anyone made any promises to you about what's actually going to happen at sentencing, which is inducing you to plead guilty here?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right. Any questions for me then at this time regarding anything we just talked about? The rights you're giving up, the penalties you face, the offense you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with your plea of guilty?
No, Your Honor.
All right. Then what's going to happen now is the prosecutor here, she's going to explain for me what she believes the evidence would demonstrate at a trial if we had to have a trial. I want you to listen to her because I have some questions about that for you.
Okay.
So, Ms. Gretzky?
Your Honor, the evidence would show that on November 12th of 2024 in Painesville Lake County, Ohio, Andrea Wasik was arrested for disorderly conduct. During the transport into the jail, she kicked Painesville police officer Brandon Smith in the shin.
The evidence would show if we had a trial.
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Your Honor, I was arrested for disorderly conduct here on Richmond Street after a confrontation with some appeared to be juvenile. I had a mover driver that was moving me to my storage.
This story seems like a tall tale. I want to know what you guys think. Just listen to old Karen the cop kicker here and see if you believe it. I don't.
And when I came out of the dollar store, a young man came up to the window, banging on the window, saying that we called him a just foul name. And I didn't know anything about that. I asked the driver, did you say anything to him? I never seen this young man before. He had two other juvenile young ladies standing in front of the truck. And he was banging on the window, saying some foul things. And eventually I asked the driver to, because my phone was there dead, and he went to call the police. The kid yelled, run, and they all ran. And then we sat there for a minute, and when we backed out of the driveway at the dollar store to go to Richmond Street, they ran behind the BP. They came with a mob of kids, and they were banging on the trucks, and one of them had some object underneath his shirt, and they were banging on the truck, and he said he was going to blow the driver's effing head off. I was in panic mode. I had PTSD, and I had very bad anxiety that morning.
Anxiety leads to constipation.
And I hadn't taken my medication, and I started seeing things coming in and out. I grabbed my phone, and I do remember calling the police and the police officer coming. At that point, I was swearing, cussing. I was just out of control, but I was in the vehicle. I never got out of
I was full Karen, Judge. I was full Karen. I'll admit to that, but not the actual charge.
the vehicle. And I was trying to remain calm, and he asked me to get out of the vehicle, and that's the last thing that I remember is pointing out who two of the juveniles were. And he asked me to stop swearing. I remember that. And then from then on, I don't remember anything after that.
So you remember, you just took about 5 minutes to give me every special little detail of this incident, but when it came time to the actual time of when you assaulted the officer, you just miraculously can't remember.
I don't know when I assaulted the officer, if I assaulted the officer. All I know is...
Well, you're pleading guilty to it, so maybe we're not. Maybe we were having a trial. I was told you were coming in to plead guilty to assaulting a police officer. I wasn't told that you were coming in here to tell me you can't remember anything and maybe you didn't even do it.
Well, I'm pleading guilty to it.
Well, did you kick the police officer in the shin?
I do not remember, Your Honor. I do not remember. I only remember up to the part where he asked me to get out of the car.
Well, part of it, when I consider whether someone gets probation or not, it's whether they show any genuine remorse. And you remember every detail of this incident until the allegation where you kicked the police officer, and just for some reason you can't remember that. That's not true.
I'm guilty. I'm guilty, Your Honor. If my behavior was anything like it was that I remembered, then I'm sure that I did it. So generally, I am remorseful for this, yes.
Doesn't sound like it.
You catch that little sounds like it? The judge is mellow, but he's thoroughly disgusted.
Well, as to the charge of assault on a police officer, a felony of the 4th degree, what is your plea to that count?
Guilty, Your Honor.
I have in my possession here a document called a written plea of guilty and judgment entry, which sets forth everything I've just talked about with you. Before I can accept your plea, I need to make sure you understand the document and you sign it here in open court. My understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Tomic, is that accurate? Did you go over that with Ms. Wasik and review it with her, read it to her?
Yes, Your Honor. Prior to coming in the courtroom, we reviewed the document and she had an understanding of the document.
Is that correct, Ms. Wasik?
Yes,
You
Your Honor.
understand what the document says?
Yes, Your Honor.
Also appears you signed this document. Did you sign it?
Yes, Your Honor.
Ms. Tomic, did you witness that?
Yes, Your Honor.
Ms. Gretzky, you as well?
Yes, Your Honor.
Very well, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect, the defendant was here in open court with her lawyer. Advised that our constitutional rights made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. find the defendant guilty of count 1, assault on a police officer, felony of the 4th degree in violation of 2903.13a. Counts 2 and 3 will get dismissed at sentencing, but I'm going to continue sentencing, order a pre-sentence report and investigation, psychological evaluation. I'll continue bond at defendant's own recognizance. What that means, as far as bond goes, I'm continuing your bond, so there's nothing more you need to do about that, except that you need to comply with the conditions of your bond. One of those conditions is that you don't use any drugs. Is there an issue with that? Drugs or alcohol?
No, Your Honor.
No, Your Honor, I've had many conversations with Andrea, and she indicated to me she does not have an issue with drugs.
Okay, thank you. But that is a condition. You may be requested to give urine samples. If you are, you need to provide those samples, and they have to be negative.
Your Honor, may I speak on to the point of drugs and alcohol in this case?
Okay.
It was reported in the police report, and the defendant was not the driver in the vehicle, she's a passenger, as she stated, but there was evidence that the defendant was under the influence of alcohol at that time. Officer stated they smelled it.
She's telling me she's not, and if there's an issue, then she doesn't tell me she's not, then she goes to prison. I don't know.
that she might just go to prison for lying to me in open court here, which she was lying. She was lying. There's no doubt about it.
You're going to have to give urine samples. If they come back positive, your bond will be revoked and warrant will be issued for your arrest. You understand that?
Yes, Your
If
Honor.
there's an issue with drugs or alcohol and you're not being open about it, and if we find that out, I'm not going to have any assessments done to address that, so we have nothing to do, and you're going to leave me no choices at sentencing. You understand that?
Yes, Your
All
Honor.
right. You also need to make sure you appear at all future court dates on own recognizance bond. If you don't, that's a separate felony you can be prosecuted for and sentenced up to 18 months in prison. When's the sentencing stand?
June 9th at 2 o'clock.
So June 9th at 2 o'clock, you need to be here, you need to be on time. That's the date of your next hearing. Now, before that, you're going to have to go to the probation department for some interviews, but if you don't do that, your bond will get revoked. But if you don't show up for the sentencing, that's a separate felony you'll be prosecuted for. You understand that?
Yes, Your Honor.
Now, when you go to the probation department, the whole purpose of that is so they can learn about you and get the information they need to prepare a report. They have to conduct an interview with you. It's important you're open and honest with them when you talk with them, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they're going to let me know that, and I'm going to consider that at sentencing. You understand that?
Yes, Your Honor.
That includes not just lying, but minimizing anything, exaggerating anything. That's included in that. You understand that?
Yes, Your Honor.
Also, for me to be able to consider probation as an option, this report has to be completed. Without a report, in order to get the report, they have to conduct the interview with you. So without an interview, they can't do the report. Without a report, I can't consider probation. So it's obviously important you show up when you're supposed to, on time, at the probation department, so they can do the interview with you. Because if they can't do it, and they can't do a report, and with no report, I can't consider probation. Even if there's a joint recommendation for it, I can't do it. You understand that?
Yes, Your Honor.
All right, so you're going to leave here now. You're going to go to the probation department, meet with them, get some dates to come back for your interviews, and you should be on your way after that. So make sure you go there when you leave here. Okay?
Yes, Your
All
Honor.
right. Ms. Thomas, anything else?
Nothing further, Your Honor. Thank you.
Mr. Gretzky?
No, Your Honor, thank you.
Thank you.
All rise. Good morning, Mr. Anaya.
Morning.
All right, Mr. Anaya is here
Okay, Mr. Anaya is a vibe, and not a good one.
on a criminal trespass. Ms. Vandenbosch, what is the location of the trespass?
Sorry, Your Honor. Sorry, Your Honor. What was the name of this?
David Anaya.
David Anaya. Oh, Your Honor, he refused to take the call. So, I don't have any information on him. The only way that I can do it is proceeding through, just direct examination.
Okay, give me a second. Ms. Vandenbosch, what is the location of the trespass?
405 McCarthy. It is his separated wife's home.
He gives the same address as his residence. Okay. Ms. Herrera, you may proceed by question and answer.
Mr. Anaya, where is it that you live?
405 McCarthy?
Not 4505, but 405 McCarthy?
No, 405 McCarthy.
Okay,
405. 405
405 McCarthy.
McCarthy.
Sir, who do you live with?
My wife.
And you are,
Lilia Anaya Viestas.
is she the complaining witness?
Yes, she is.
Um,
I did not get arrested at the 405.
where does your wife live?
All of this awkwardness was caused by him refusing to meet with his attorney prior to the hearing.
She lives at the 405 McCarthy.
And you live at the 405 McCarthy.
Answer the question.
No, it's look, it's all 405, not 45. 405 McCarthy. It's all 405. I don't know where you're getting 45 at.
Correct, sir. Just calm down. I just wanted to know if you and your wife live together.
Yes. For the second time, yes, ma'am.
You do.
Yes, ma'am.
I'm a little bit confused then because Ms. Vandenbosch, I'm sorry, sir?
Yes.
Are you on the lease? Is this a home you're buying?
It's a rental. We're renting the house.
And you are on the rental agreement?
Yes, ma'am.
Are you paying rent?
I'm paying rent. I'm paying bills. Everything. We also have a car that is under our name. It's just a mess.
Okay, thank you. I understand. I understand, sir.
Yeah, she's making the best argument available for you, a-hole. And you jumping all over her is not helping your cause. And it doesn't help your cause. And the judge is noticing all of it.
Sir, are you able to post bond at all?
What's the bond? 500?
The bond is at 500.
I believe I can.
Do you have any cash?
I have $40 in my.
Okay, you have $40.
Yes, ma'am.
Okay.
How much would it be to bond out?
I don't know, sir, but let's ask the judge to see if he's willing to reduce the bond to a PR bond. I'm a little bit confused.
They also said that I had a warrant for my arrest for criminal trespassing.
Mr. Anaya,
Okay, just a minute.
Mr. Anaya,
And they're
okay,
trying to find it.
please hold on, Mr. Anaya. All right. I need you to only answer the questions that are being asked of you. Do not offer any more information. All right.
Yeah, so first you want to be a complete ass to your attorney who's trying to help, and by the way, doing a good job. And then you want to mention any other warrants you think might be floating around out there. Always a good approach at a bond hearing.
If after we're done, you have some questions, I will try to answer them. But we need to conduct these hearings in an orderly manner. Do I make myself clear, sir?
Yes, sir.
All right. Ms. Herrera, please continue.
Thank you. And you have lived in El Paso all your life, is that correct?
Correct.
Okay. And you are working, sir?
Yes.
And
On and off.
where,
Yes.
okay. Are you working currently?
Yes, if I get out right now, yes.
Okay. And where do you work?
At year one. Electric.
And
Electrical.
Year One Electric, and you've been there for 11 months. Is that correct?
Something like that, yes.
Okay. Do you have any other charges or any past charges, any pending
ma'am.
charges?
No, ma'am.
Okay. Thank you so much. Your Honor, I'm a bit confused in terms of how he can have a criminal trespass at his own home. But thank you, Your Honor.
Thank you. Ms. Vandenbosch?
Yes, Your Honor. In Texas is a juvie, a 98 criminal mischief and POM where they filed the petition as an adult, 2015, a criminal mischief dismissed, a failure to stop and render aid. He was convicted, given 2 years in Texas Department of Corrections. 2019, an AFV deferred, a VPO dismissed. 2019, a VPO dismissed. 2020, criminal mischief, he was placed on probation. 2023, a criminal mischief that was dismissed. This incident was 4:15:25 at 1500 hours. The officers were dispatched to 405 McCarthy. The complaining witness stated that she's been married to the defendant for approximately 3 years, but they were no longer together, and both parties had separated. They had agreed that the defendant was not to be living at the residence. He has no financial ties to the property. The victim's name is Lila, Lilia Viescas, Viescas. The complaining witness stated that she was in her backyard. The defendant came to her front door, went through the fence that had been locked, started knocking on it. She asked him to leave, but he refused to leave. Then she told the defendant, "I'm going to call the cops." At that point, the defendant left the property. During the investigation, the officers determined that the complaining witness is the owner of the home, and that there in fact had been a criminal trespass warning, a field contact with the defendant a few months back.
What is the name of the complainant?
Lila, Lilia
Lilia.
Viescas, Viescas.
Your Honor, I'm still not clear whether the officers actually looked at any documents indicating that he was neither a resident nor also co-owner of the home. So I don't understand this in terms of how you can be a criminal, how you can be criminally trespassing if he didn't verify it.
My jewelry. Okay.
No, just a minute. Please be quiet.
Okay. All right. You said Lilia Viescas is the complainant in this case?
Yes, Your Honor.
Okay. All right, Mr. Anaya, I'm going to deny any bond reduction on this case. In fact, I'm going to increase the bond because I find the bond to be insufficient. I'm going to raise it to $5,000 cash corporate surety. It's based on your prior criminal history, including violations of protective order against the same complainant, Ms. Viescas. Do you understand that, Mr. Anaya?
Yes, ma'am.
All right. Thank you very much. Mr. Anaya is currently on probation, deferred adjudication for criminal mischief, where it is alleged that he burned some property belonging to a railroad company. He has a history of assaultive behavior against Ms. Viescas, including some convictions for violation of protective order.
Oh, we got another vibe here.
Maybe. Let me see if I can find this again.
This is Red Rider's fault over in Discord, excuse me.
I never get to say this, but since you can't find me, do I get to get out?
Okay, Ms. Sainage, I'm calling your case and I need you to remain quiet, okay? Until your attorney tells you to say something. I don't want you to say something against your interest. So this is People versus Christina Sainage, files 3519 of 25 and 2757 of 24. Mr. Warden is here on behalf of the defendant. Have you had an opportunity to go over the pre-sentence report with Ms. Sainage, and is it accurate and complete?
We have reviewed the report, Your Honor, and it is accurate. Well, it's accurate. It's old, and so I suppose in elocution, I'll give you the update procedurally where we're at.
Okay, so that's what I was curious about. So why don't you do that right now? I wanted to know where she stands on the possession of meth case and it's pending.
Yes, Your Honor.
Oh, hang on.
This is really an ugly scenario.
Okay, go ahead, Mr. Warden.
Your Honor, this case, 242757 is a larceny case where she took money belonging to her stepfather, took jewelry and coins belonging to her mother and stepfather back in March of 2023 and pawned it for the, I guess, consumption of drugs, for buying and consuming drugs. In 3519, that was a traffic stop in August 24 of 24, where she was found to be in a very small, or possession of a very small amount of drugs that tested true narc for fentanyl. And so the first case, the theft case, was originally set for sentencing back in February. Your Honor was concerned about basically this case and then the possession of methamphetamine case in Leelanau County. And so we kind of merged these and adjourned them. And that was set for sentencing on April 3rd. She did not show on April 3rd, and a bench warrant was issued in the theft case. In the 3519, the use case, she did show up for sentencing on the 4th. That's April 4th, the next day. At that point, she was late. Christina, let me talk.
Oh.
The next day she showed up, Your Honor. She showed up late and was disheveled. You had her drug tested, and she came back positive for amphetamine and methamphetamine, and you remanded her and again reset these cases to the 18th. We did make a record, Your Honor, and on that date that she had the Leelanau County case where she was set for sentencing on April 7th. So again, she was remanded on April 4th to Grand Traverse County. She failed to appear on April 7th, but that's because she was incarcerated in Grand Traverse County Jail. And so she's now in bench warrant status in the Leelanau County case, having pled guilty to, give me 1 second, having pled guilty to possession of methamphetamine and furnishing contraband to a prisoner with 7411 consideration at sentencing. So she's in bench warrant status in that matter. Complicating things, the victim, her mother, who she was also violating bond to take care of, passed away on April 11th. So quite a lot has gone on. She's now sober, having been in jail for the past, looks like 14 days. She had jail credit prior to that. The PSI recommends some jail time, no probation, but clearly this is the person who's spiraling out of control and needs the structure of either community corrections or probation. Her mother's visitation and funeral is on April 22nd, so that would be next Tuesday. And at minimum, we'd be requesting a furlough for that day. Mr. Burdett represents her in the Leelanau County case and is aware of that. I think he's also in the courtroom. So that would be the request. That would be the request today. As far as sentencing, Your Honor, she's 36 with no prior history, clearly losing control to addiction. And so she needs the structure of, quite frankly, community corrections.
And when's her sentencing in Leelanau County then?
It was April.
It was in April 7th, but it's hasn't been reset yet because she's here and we were unaware that she was in the Grand Traverse County Jail.
Okay. Thank you. So, Mr. Warden, what else would you like me to know?
Like I said, Your Honor, at this point, I think we kicked the can down the line enough, waiting for what's going to happen in Leelanau County. I think at this point, either we defer that again, or this court simply gives her a sentence that will give her the structure to hopefully, work on the addiction problem and break it. And that, like I said, I would ask the court to give her a lengthy term of probation and immediate community corrections consideration with a furlough for the day on Tuesday.
I want to be out today.
Okay, I would like to hear from you at this time, Ms. St. Ange. Anything else you'd like to add?
I'm grateful for getting out on the furlough on the 22nd. I would love to be out for today, but I will accept on the 22nd. I am grateful for everything that everybody has been able to let me see my mom for 4 months. I'm grateful. I'd be grateful to get out today, but I'm even more appreciative for on the 22nd. I'm ungrateful for the time. I was ungrateful in the past, I'm sorry I acted ungrateful, but everything happens for a reason. You saved my life on the 11th. So I appreciate you and anything that you do and everything. I really do. But I mean, like I said, I'm hoping for today to get out, but I'm not. I love the 22nd. I want to see my mom.
So what's her bond in the felony case?
It's no bond, Your Honor. So there was a warrant issued on the 3rd, and that's the bench warrant from the prosecutor's motion to revoke her bond. Perhaps Mr. Burdett would have more information, but then she's also in bench warrant status, having missed the April 7th sentencing where she was incarcerated in Traverse City. So she's in warrant status. She would have to get transferred, or she would have to have the court address the warrant, the circuit court address the warrant.
May I say something?
Christina, let the judge and I talk.
Okay. I know a lot has happened. That's why I was just...
Okay, so is that being addressed in the circuit court, Mr. Burdett?
It hasn't been addressed yet. We don't have a hearing date. So there was a warrant for violating the bond, and then a warrant for...
And that's because of the personal protection or the no contact order violation, is that right? No?
I believe it was a testing positive.
Oh, testing positive. Okay.
And then when she didn't appear for the pre-sentence interview and didn't show up for sentencing, the judge issued another warrant. Well, basically another warrant. So there is no bond. If the court grants a furlough today, I can try to do a skip and order with Joe Hubble to get a furlough for Tuesday. I could probably get that out today and see if Judge Eisenhower will sign.
But I would love to get out for today and prove that I'm not going to be a problem.
You know, what concerns me most is that's all I've heard is let me out, let me out, let me out. And that is drug-seeking behavior. And that's exactly what I would expect if she were granted a furlough. What am I supposed to do? Send a corrections officer with her to the funeral to make sure she's not using? This is the thing. The victim in this case was your mother.
Yes. Yes.
And you miss out when you're in jail. That's what happens. You miss out.
That's why I'm never touching drugs again. My mom would be so disappointed right now. I've already disappointed her enough, and I would love this opportunity to prove that I'm not going to anymore.
Okay, so I'm not going to do anything. There's nothing I can do in the Leelanau County case. That's been bound over, and so I don't have anything to do with the bond in that case, but I'm not going to let this furlough idea interfere with what should happen in the case. So anyhow, this is sentencing on a conviction for larceny, 200 to 1,000. The facts are the defendant on multiple days took jewelry from her mother's, pawned it at Ace Buyers, and she said she did that to buy cigarettes, gas, and drugs. Said she was under the influence of drugs at the time it happened. Now, this goes back a couple of years, but it's obvious the drug problem has persisted, and there was an evaluation, and it indicates that the defendant has a severe substance use disorder. That's the most concerning diagnosis that Catholic Human Services gives. It says severe opioid use disorder, but we know there's also other substances. What it's recommending is outpatient substance abuse counseling. I think she probably needs inpatient myself. And then also the usual supports and abstinence from alcohol and drugs, etc. The defendant does come to the court with no prior criminal history. Oh, I'm sorry. There was a possession of narcotic. Okay, so those are all after this offense. So no prior criminal history before this, but obviously she's had several problems since then. And most concerning is the felony charge that she's facing in Leelanau County. So ordinarily, I would agree with the recommendation in this case for straight up jail time and no probation. But I'm willing to go along with the community corrections recommendation. I don't think regular probation would be productive. I think she needs more oversight than that. So, to that end, I'm going to waive the fines, costs, and the attorney fee. There will be a $75 Crime Victims' Rights Fund fee, $50 judicial system fee. The restitution amount is $2,901.17. And I guess that would go to Eugene Sayer. He's listed as a victim along with Helen St. Ange. And I assume that's her husband.
They were never married, but they might as well be. They were together forever, or for a very long time. So.
Okay, thank you. That kind of says it all, and she should be entitled to that.
Yes, he does.
So what I'm going to do is order that the defendant receive treatment for substance use disorder, and that'll be the purpose of a probation in this case. And to that end, the defendant is placed on probation for a period of 2 years. The terms of that probation are that you're not to consume or possess any alcohol, no mind or mood altering substances, no non-prescribed medications or illegal drugs. It'll be 8 times per month drug testing, twice daily preliminary breath testing. Those are the random tests. There'll be discretionary testing as well for both drugs and alcohol. You're not to enter any bars or casinos. You're also not to reside where any of those substances are present. You're not to engage in any violent, threatening, intimidating, or harassing behavior toward anyone. No possession of firearms or weapons. You're not to reside where there are firearms or weapons. And you are to follow any of the recommendations made by the folks at Catholic Human Services. And let's see. The jail sentence is going to be well, we'll make it 6 months, and that is with community corrections. So what that means for you, Ms. St. Ange, is I'll make you eligible for immediate consideration by community corrections. So what they'll probably do is develop a plan for you, which might include inpatient treatment. And their goal is going to be to get you into a treatment program, but they're not going to let you out until they have that plan in place. But I will make you immediately eligible for review.
Okay. I have.
Hang on, Ms. Sainaj. You're also to report any run-ins with law enforcement to your probation agent. And you're to attend at least 3 times per week group recovery meetings, obtain a sponsor, and follow any other recommendations that your therapist may have, including for possible inpatient treatment. Is there anything else that you would recommend, Mr. Warden?
Your Honor, you called both cases, noticing her use case is up for sentencing next Friday, the 25th, and that is 25/35/19. I would suggest that we either address that now and consider a time served sentence or make that sentence duplicative with this sentence.
Okay, so we'll make that, the sentence in that case, duplicative with this sentence. So that is, again, a community corrections case. I think Ms. Martin needs the number on that.
Well, no, I just need to clarify something because I have both sentencing dates for today, 35/19 and 2757. So I just put her on probation for the
That's right.
narcotic case. And I didn't give her any probation in the larceny case. So I don't know what you want to do there, Judge.
Okay, so it's going to be one community corrections case. I'm going to do the same sentence in both cases. That's what we'll do. It'll be the same fines and costs. In other words, no fines and costs, just the judicial system and victims' rights fund fee.
Can I point something out?
Christina?
You know what? You need to talk to your attorney. That's what he's here for.
Yes, sir. I'm sorry. I apologize.
Okay. All right. So that is it for this morning. You need to take care of yourself right now. That is the most important thing. And hopefully these services will get you there. Is there anything else for you, Mr. Warden?
No, Your Honor.
Or Mr. Burdett, since you're here, anything else?
No, Your Honor. I will just address the bench warrant up in Leland.
Okay. All right.
One
Thank you.
question, Judge, if I could. Time served on 6 months.
It is.
Yeah.
Well, it's time served, but again, she's not going to be released until Community Corrections has a plan in place.
Yeah.
Oh.
Do you want a breakout room with your client, Mr. Warden?
I think that would be helpful, Your Honor.
Okay.
Not really, but it'll shut her up. Okay. All right. I got some fun stuff over with Judge Lal too. Just a little bit. Love is in the air over there.
Domestic violence case against her with regards to you. Unfortunately, you don't have the decision-making authority to decide whether to proceed with these charges. That lies solely with the prosecutor.
Oh, shoot.
No, it's not you. All right. Ms. McCloud?
No.
We'd ask.
I want to start at the beginning.
2020 Pony pissed out another simple assault conviction and a 2019 ag assault first offender.
Thank you. To be Mr. Chate. Any prior?
Hey, Your Honor. Good afternoon.
Oh, Ms. McCloud, I'm sorry. Yes,
Yes,
good
Your
afternoon. Your attorney, Ms. Campbell, is Ms. Maureen McCloud. Any priors, Mr. Howard?
On probation for battery out of state court. Open case out of Clayton County. Criminal damage to property, 2nd degree. Burglary, death by taking. Open case out of Troup County. Disorderly conduct, simple battery. 2024 FTA. 2023 battery conviction. 2020 Pony pissed out another simple assault conviction. And a 2019 ag assault first offender.
Thank you.
I think Andrew can fix her. I really do.
Ms. Allen?
Good case, Your Honor. Thank you.
This is an incident from the 17th of April, so yesterday, 2025. The location is 2205 Jones Road in Atlanta. Officers arrived to the scene and spoke with the victim, Quintavious Raines. He said he'd tried to gather his belongings at the residence of the defendant and leave after an argument when she took his phone and his backpack as well as other belongings, and she wouldn't return them. She eventually returned his backpack, but she took his phone and she threw it outside in the yard and he was unable to find it. He reported that the defendant told officers something about a dislike of body hair. This is what upset the defendant. The defendant, per her statement, officers tried to help locate the phone and find it. Mrs. Campbell was asked about the phone.
I mean, he did call her a hairy bee, you know.
Multiple times. She changed her story. She made a bunch of inconsistent statements and actually lied to police. They eventually located the phone and returned it to the victim. She admitted she'd been in the house the whole time, and she had been trying to get the victim to stay. There was a witness, the sister of the defendant. She did corroborate that the victim was just trying to leave. Another person present said she saw the defendant ringing the doorbell, checking the Ring camera, running with belongings away from the victim to keep them away from him. Officers looked at camera footage as well and saw that, observed the defendant arguing with the victim and the victim asking for his items back. The defendant was clearly causing a scene and yelling loudly, and that's the basis for the disorderly conduct. Based on her history, her open cases in multiple counties, we're asking for $1,000 surety. If you would sound for Mr. Raines.
Quintavious Raines, if you're on Zoom, this will be the time to unmute and start your video. No, it's not here. All right. Ms. McCloud?
We'd ask for no
Yes.
contact, Your Honor.
Okay, understood. Thank you.
Yes, Your Honor. I do not believe certainly that the theft by taking is a justified charge here. My client tells me that she and the alleged victim are in a relationship. They were just having an argument. There was, whether or not she took his phone, hid his phone, threw his phone, it hardly amounts to theft, in my opinion. I don't believe that it satisfies the legal definition of a theft by taking. My understanding also, Your Honor, is that the alleged victim was not the one who called the police, that the police may have been called by a neighbor who heard them arguing. I understand my client does have some history, Your Honor, but given that essentially what happened, they were just in a heated argument. There was nothing about anybody striking each other or anything. It was just a couple having an argument. I would ask the court to consider signature bond for her. Nothing further, Your Honor.
You understand that she's got an FTA from 2024, so.
I did hear that.
Okay. On the theft by taking, that's going to be a 500 signature bond through the jail. On the disorderly conduct, it's $1,000.
I actually thought the attorney, it doesn't exactly work, but I thought the attorney's argument was very smooth there.
Surety. This is a $1,500 split bond. No further contact with Quintavious Raines. No illegal drugs, no alcohol, no weapons. Thank you.
Thank you, Your
Next
Honor.
court date is May 1st.
That's a SOB jail judge?
For count 1,
Yeah.
and count 2 is $1,000 surety. So it's a 1,500 split. And did you get the information on the position number 1?
Yes, I did.
All right, thank you. Next case?
And Your Honor, I'm supposed to be in a breakout room, but I haven't seen the link to speak with the Wolof interpreter and my client.
All right, and what's your client's name?
Mr. Sal, Mamadou Sal.
All right, as soon as I think Mr. Saul is placed in a separate room, we can have a breakout.
Yes, right now we don't have that other room available, so.
Oh, I see.
Wait patiently.
No worries. I was just wondering what happened because I was told we were going to be in a breakout
Yes,
room.
you will be in a breakout with the interpreter, but they need to make sure that he's physically in a location that nobody else is around.
I understand now, Your Honor.
All right, thank you. Who do we have now in courtroom 2?
Position 3, Miss Christmas.
All right. Courtney Dawn Christmas is accused of simple battery family violence from April 15th of this year, case 25 CR 2029J. Ms. Christmas, you've been advised of your right to remain silent. Your attorney is Mr. Chate. Any priors, Mr. Howard?
Second, 2010 battery DV was NOD.
I'm sorry, but I really can't take PD with the last name Chate. I should be more mature than that, but I'm not.
Thank you. Ms. Allen? Thank you, Your Honor. This is an incident from April the 15th. The location is 2124 Chattahoochee Circle in Roswell. This is an altercation between roommates. The victim in this case is Jennifer Hill. Police were called to the location where they spoke to Mrs. Hill, who reported that she'd been assaulted by her roommate, the defendant, Mrs. Christmas. She said she'd been living at the location about 3 weeks and that there'd been some tension. She showed officers a video that she'd recorded. In that video, you could hear a physical struggle. The defendant's son is heard telling her, "You shouldn't have done this." In addition, it shows the defendant lunging at the victim before the victim, loses the ability to hold the phone straight, and then you hear the rest of a physical altercation. Victim Hill reported that she had been grabbed by her neck and slammed to the ground. She didn't have any visible injuries at that point, but she complained of ankle pain and was worried she'd sprained it as a result of being thrown on the ground. EMS responded and transported the victim. Police tried to make contact with the defendant, who the victim reported was actually inside the house, but no one responded. They called her on her number and left her a voicemail. No one answered. We tried to get in touch with Mrs. Jennifer Hill today, but were unsuccessful. We're asking for $1,000 surety, Your Honor, no contact with Jennifer Hill, and to stay away from wherever she's currently living. We'd ask for some anger management. And in case Mrs. Hill got our message, would you sound for her, please? Thank you. Mr. Chate, do you have any objection to the stay away and no contact?
Let's see. I'm not sure, Your Honor. I didn't discuss the address with my client. Ms. Christmas, do you live at the incident location?
Yes, that's my home, sir.
Okay. In that case, I would object, Your Honor.
All right. Bond is going to be set at $2,500. It's a signature bond through pretrial services, level 1. No further contact with Jennifer Hill, and to stay away from the incident location. She can return to the location one time only with a police officer to retrieve her belongings, and then she'll need to update the court with a new residential address, which has to be more than 200 yards away from the current location. No illegal drugs, no alcohol, no weapons, and she needs to attend and complete 2 anger awareness classes with pretrial services. Ms. Christmas, you have a signature bond where you'll be reporting to pretrial services once a month. You'll need to comply with these conditions, and if you fail to do so, the signature bond will be surrendered, and you'll have to pay for your bond the next time. That's it. Thank you.
There you have it, people. Chate on behalf of Christmas.
Oh, and no contact with Jennifer Hill. That I think I said that also. If I have a question to ask later. You can contact your attorney, Mr. Alex Chate, at the Public Defender's Office. Okay. Thank you.
Good afternoon, Judge Law. This is going to be position number 16, right?
Okay. Dariana Leigh Wright, is that correct? I'm sorry, Deputy Francois, the individual is quite far away from the screen. Is that a male or female?
Female.
Okay, thank you.
That's awkward. I mean, like I don't blame the judge for it, but it's awkward. There's no two ways about it.
Got it. Thank you. This is State versus Dariana Leigh Wright. Miss Wright is accused of 8 misdemeanor offenses stemming from a traffic incident on April 8th, 2025, case number 25 CR 2038G. Miss Wright, you have a right to
8 offenses from one traffic incident. She must have just gone buck wild. I don't know what happens here, but
remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you at the present time is Mr. Michael McLean. You are accused of fleeing and attempting to elude a police officer.
At least you don't have the shite attorney.
2 separate charges of speeding, reckless driving, failing to report striking a fixed object, an adult seatbelt violation, misdemeanor possession of more than one driver's license, and failure to obey a stop sign.
12 adult arrests. That's an open case out of Alabama. It says flight to avoid, attempting to elude police, felony.
Okay.
2 open shopliftings in Fulton. 2019 shoplifting conviction. 2017 theft by taking trespass conviction.
Thank you. Ms. Dunlap?
Thank you, Your Honor. Defendant was traveling in her Honda Odyssey at a high rate of speed in a residential area. Officers first estimated she was going 25 miles over the speed limit. They tried to initiate a traffic stop. She continued at a high rate of speed, ran through several
All right, full gangster in a Honda Odyssey is also kind of funny. I'm not going to lie.
stop sign intersections, initiating a pursuit. She continued through the residential area, disregarding several more stop signs, increasing her speed. She ended up running to a fence, crashing the car before exiting the car, trying to flee on foot. Officers had to chase her and continuously instruct her to stop resisting arrest. She tried crawling away. She wasn't putting her hands behind her back. She began to kick the officer as well. Seeing as though she has an open attempting to elude police officers, and we did recommend this as a possible felony upgrade from the DA. We haven't heard back yet just because the criteria for fleeing or attempting to elude police officers meets the felony level. The state is looking for a $2,000 surety on the fleeing or attempting to elude the police officer, $1,000 on the speeding, both speedings, reckless driving, surety, $500 on all other counts. And I think that's a total $7,000 surety. No driving without a valid license, and no drugs, alcohol, or weapons while on bond.
Mr. McLean?
Your Honor, McNair High School is where Ms. Wright has graduated from, and she has worked in restaurants and worked outside doing landscaping for a company. She does ask the court to consider the lowest possible bond. If that would be a signature bond, that would be super. If it's not a signature bond, she would like to recommend $1,000 to $2,000 surety bond.
Is this a bind over case?
Yes, this is a bind over case.
All right. And does she have a hold in Chambly Police Department? I see a hold paperwork over here. So
Maybe so, yes. I'm not sure.
I believe so as well, yes.
I see Chambly PD. Okay. All right. On the seatbelt violation, that's going to be a $50 signature bond through the jail. That's the only one. 1, 2, 3, 4, 5, 6. Okay, on each count, all the other charges is going to be $1,000 surety. The total bond is going to be $7,050. It is a surety bond. No further driving at all until further order of the court. So that means, Ms. Wright, you are not permitted to drive as a condition of your bond until there is a court order allowing you to drive. And if you do operate a motor vehicle once the suspension is lifted, then you've got to make sure that you have a valid driver's license, adequate insurance, and proper registration. Your next court date is May 1st.
Judge, you said the total bond for the surety is going to be $7,050?
Yes. So it's been, and the surety bond is $7,000 and the seatbelt violation is $50 signature bond through the jail. So it's a split bond.
Okay, thank you, Judge.
Got position 10, Ms. Rapley.
This is State versus Tony Rapley. Ms. Rapley is accused of 2 counts of battery family violence from April 17th, 2025. Ms. Rapley, you've been advised of your rights. Yes?
Third, 2021 battery DV dismissed.
Thank you. Ms. Dunlap?
Just so you're aware, Your Honor, she actually saw you for that 2021 battery DV. It was given to diversion, and it's the same victim, her husband, that's in this case.
Mm-hmm.
This incident date happened at, I believe it's 725 Pleasant Hill Street. I do have a 39 Hill Street as well that was in the warrant. Officers responded in reference to a domestic dispute. They met with the defendant, who told officers she was assaulted by her husband, who was the victim in this case. She stated that he got upset with her. Once they got inside the parked car at Pleasant Hill Baptist Church, he punched her in the head, grabbed her by the hair and choked her, and grabbed her arms. When officers asked about her injuries, determined she didn't have any at all. Officers then spoke with the victim, Mr. Roderick Rapley, who told officers the defendant had asked him to come to Canton Street. When he got there, he didn't see her, began having a conversation. When she saw him speaking to other women, she became upset and pushed him as they were leaving, physically attacked him. The victim stated the defendant pushed him to the concrete where he sustained abrasions to his right knee. And when they got back in the car, she continued to try to fight him, scratch him in the face. Officers observed several injuries on the defendant. Our office did have a chance to speak to the victim. They asked him what took place. He said they went to the location after 5, that the defendant, her daughter, and her friend went up there before him. He came there later. He said he hangs out with a lot of guys who are single and that she acts single. He said he came up there around 7 and they had guys around them and was watching them. Their grandkids were there as well. Once he was speaking to people and making conversation, the grandson alerted the defendant that he was there, and she called his phone, said she's ready to leave. She started pushing, shoving, and cursing at him, accusing him of talking to other women. He said she did more when he was in the car driving, trying to attack him, grabbing the steering wheel, hitting him, scratching him. He didn't want anything like this to happen. He stated he didn't even know she was in jail. He thought she was at their daughter's house. Defendant may have called the cops. He said he didn't call the cops and that she had left their residence. The cops came and started asking his questions. We did ask him if this happened before. He said yes. And police said one of y'all have to leave the residence. He said they were talking to her and they never came back to the house, and neither did she. He just now found out she's been in jail, and it's been a while since they've had something like this, which I mentioned the 2021 case. They've been married for 15 years. Exciting and new. And this is the first time I guess she's ever gone to jail. Given that she has a previous case with this, even though it was dismissed, I guess, for diversion for the same victim, this is looking for a $4,000 surety bond in this case. I'm going to ask for no further contact with Roderick, Rapley. Stay away from the home address. One day anger awareness, no drugs, alcohol, weapons while on bond, if we can sound for the victim when appropriate.
Roderick Rapley, if you are on Zoom, this would be the time to unmute and start your video. I see a Roderick's iPhone. I don't know if that's him.
All right. So now I take back everything I've been saying about marriage. It's a beautiful institution. There's no way that either of these people are getting any on the side. And I'm sure that these kids can you know, they're going to make it. They're going to work this out.
All right, Mr. McClain, you may proceed.
Your Honor, Ms. Rapley has worked for 25 years in one job. I'm getting to be in the habit of not saying what the employer was because we sometimes worry about the public watching and harassing people. I'm not saying that it happens all the time. The public is untrustworthy, but
I only need the information that's relevant.
Right.
And right
So
now,
she's
yeah, go
working. It's a public service job, and she has been doing that faithfully for 25 years in her work, and is very good at it. This is an unfortunate incident. If the court is not leaning towards the signature bond here, which I think I should offer an alternative notion in case the court is not so leaning, and a $2,000 or less surety bond would be a little more affordable than the 4 that the state is proposing. But she does work full time, and we'll try to make the bond. Thank you.
All right. And Roderick's iPhone, did you want to address the court? I see, in all these days we've been doing Zoom.
Can you hear me?
Mr. Rapley, we can hear you. We cannot see you. Your video is reversed. We can see whatever room you're in. You need to reverse your video. All right. Bring the device closer to your face. Okay. Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Are you in a public area? Are there people around you?
No.
Put your mask down. Thank you. All right. Do you live at the Bush Street location in Roswell?
Yes.
Does Miss Rapley live with
Then why do you have the mask on? Get a hold of yourself, man.
you?
Yes.
And do you have anything else to add with regards to this alleged incident at Pleasant Hill, I think? Or
Yes. I would like for the state to not press any charges against my wife. Some things, and just recently lost my father-in-law, and I know she haven't really grieved, and a lot of stuff just coming out right now with her. So, yeah, we just buried him on the 12th of April.
So the allegation is that you were probably at a social gathering place speaking to
Yes, I'm sorry. They normally have this thing at Roswell. It just started back yesterday. First, they have it every year, and I never went. They normally always go. The kids, grandkids, my wife, my daughters, them. They always go. It was my first time. She asked me to come, and there was a lot of people up there. They goes because like they call live after 5, and they go up there and they get their spots, their chairs and everything like right before 5. And I walked up there around 7:45, something like that. And my first time ever going.
Okay, thank you. That's all I needed to know. Thank you. Please mute me. Thank you. On count 1, battery family violence, that's going to be a $1,500 surety. On count 2, battery family violence, that's a $3,500 signature bond through pretrial services level 2. Ms. Rapley, your total bond is $5,000. However, a $1,500 portion of it is going to be a surety bond. After you post that portion, then you will be eligible for the $3,500 release bond. You will have to report to pretrial services twice a month. You shall have no further contact with Roderick Rapley until further order of the court. You are to stay away from 645 Bush Street in Roswell, Georgia. You're allowed a one-time visit to the location to retrieve your belongings, and then within 30 days of being released, you will update the court with your new residential address. You cannot reside with Mr. Rapley until further order of the court. Miss Dunlap.
He wants her back on Bush Street. I mean, come on, these things write themselves.
In her prior case, did she complete a domestic violence intervention program?
I just have to double check that. I know it was diversion. Give me 1 second.
Okay. Or if Mr. McClain, do you know if your client completed a DVIP in the prior under the diversion program?
I'm sorry, Your Honor, I do not.
You do not know. Okay. While you're looking, Mr. Rapley, please understand that this is a second battery domestic violence case against her with regards to you. Unfortunately, you don't have the decision-making authority to decide whether to proceed with this charges. That lies solely with the prosecutor. So if the prosecution still wishes to pursue these charges, this will be an open active case against her, and she'll be required to comply with these conditions. If she fails to comply, the $3,500 portion of this bond will be surrendered, and she will have to pay for that portion as well. Currently, she only has to pay $1,500, and she can either do that out of her own pocket or through a bonding company. Bonding companies typically charge between a 10 to 15%, so her maximum out of pocket for that bond would probably be about $275. Ms. Dunlap, any updates?
Found the form. It's just not saying what program she completed. Sorry, Your Honor. I'm just double checking now.
Okay.
It says she completed some pretrial intervention or counseling program, but it's not telling me which one on this document in the case file.
Ms. Rapley, within 30 days of being released on this case, you will enroll in what we call a domestic violence intervention program. This is a program of 26 classes, and you will attend and complete each class at your expense, and then provide the certificate to the pretrial officer. This is an open active case, so please remember to comply with these conditions. Thank you.
Got position 4, Mr. Frazier.
All right. I think we'll leave it there. I thought we'd end on a high note with a little love story. Behave yourselves. It's Good Friday. Don't do anything I wouldn't do. I'm not bailing you out.